for raising this matter. I think I absolutely share his concern. This is a really worrying situation that has evolved here. Clearly, I hope that the concerns of the employees can be resolved to their satisfaction quickly and they can end the sit-in that has occurred. As you know, the NERA has met with representatives of the employees last Friday and informed them of their rights of entitlements and means of address. They've also provided continuing contact details, and I understand they are seeking to they're in active contact with not just the employees but also the employer in order to try to resolve the situation. You raised the issue of workers' rights. Ireland has a very significant body of employment rights enshrined in legislation, and included among these is the Payment of Wages Act of 1999, which contains protection for employees and provides a means for redress for employees who have not received their full wages from their employer. Non-payment of wages or any deficiency in the amount of wages properly payable by an employer to an employee on any occasion will be regarded as an unlawful deduction from wages unless the deficiency or non-payment is attributable to an error of computation. The Payment of Wages Act 1991 provides a right of complaint to a Rights Commissioner for any employee who has not received his or her wages or who has had an unlawful deduction made from wages. A complaint must be presented to a Rights Commissioner using the prescribed form within 6 months of the deduction or non-payment of wages that give rise to the complaint. It should be noted that a number of employee rights at this point, I understand that no such application has been made. It should be noted that a number of other employee rights come into play as a result of the closure of a business, including minimum notice and redundancy. Under minimum notice and terms of employment acts, an employee who has a minimum of 13 weeks service with an employer is entitled to notice of termination of employment. The length of notice to which an employee is entitled is dependent on the length of service of the employee and can range between 1 week's notice for an individual with less than 2 years service up to 8 weeks notice for an individual with more than 15 years service. Where an employer is unable to provide or does not provide the appropriate notice, then the employer may make a payment in lieu of the notice. An employee who does not receive their minimum notice entitlements may take a case to the Employment Appeals Tribunal. Under the Protection of Employment Act 1977, companies proposing collective redundancies, that is where at least 20 people are employed, must enter into consultations with employee representatives at least 30 days before anyone receives notice of redundancy. They must also notify the Minister for Jobs, Enterprise and Innovation of the proposed redundancies at least 30 days before any employee receives redundancy notice. The consultation with the employee representatives and notification period for the Minister can run concurrently. I understand again at this point no application for redundancy or no notice of redundancy has been served by the employer. In accordance with the Redundancy Payments Act, employees who have at least 2 years continuous service with an employer are generally entitled to a statutory redundancy payment in the event of being made redundant. The administration of the redundancy payment legislation is within the remit of my colleague, the Minister for Social Protection, who has advised that it is the responsibility of the employer to pay statutory redundancy to all eligible employees. However, where an employer can prove to the satisfaction of the department that he or she is unable to pay statutory redundancy to his or her employees, that Department of Social Protection will make lump sum payments directly to those employees. Such payments are made from the Social Insurance Fund and result in a debt being raised against the employer, which the Department of Social Protection will seek to recover. Where an employer either fails to comply with his or her redundancy payment obligations or where there is a dispute regarding redundancy entitlements, claims may be referred by the employee to the Employment Appeals Tribunal. Where an employer is legally insolvent and as a result defaults on payment of wages, an employee may also be entitled to seek redress from the state under the Insolvency Payment Scheme. These payments also cover overtime, holiday pay, sick pay, etc. In these circumstances, redundancy payment entitlements may also be made from the Social Insurance Fund. I have been informed by the Minister for Social Protection that she has received no formal notification from the company. A company may be put into liquidation by its members. An alternative is that the company's creditors may apply to the courts to have the company put into liquidation. Employees owed wages or other payments count as creditors and would be entitled to apply to have the company put into liquidation. If the employees and the employer agree that conciliation or another form of intervention might assist in resolving some of the difficulties they are facing, the State's industrial relations machinery is available to assist in this dispute if required. Even what often appears to be the most intractable of disputes are capable of resolution where both sides engage constructively in good faith in this voluntary process. The principle of good faith implies that both sides in a dispute make every effort to reach an agreement and endeavour through genuine and constructive negotiations to resolve their differences. Ireland's system of industrial relations is essentially voluntary in nature, and responsibility for the resolution of industrial disputes between employers and workers, whether in redundancy or other collective disputes, rests with the employer, the workers and their representative. But the State provides industrial relations disputes settlement to support parties in their efforts to resolve their differences. All of the agencies and bodies under the remit of my department remain available to the parties if they can be of assistance.